I'm Drew Stevenson, and this is a video for my professional responsibility class about ABA Model Rule 1.9, which deals with duties to former clients or conflicts of interest for clients that you represented in the past. Now, remember that we have some other rules, 1.7 and 1.8, that deal with conflicts with current clients. But here we have some sort of different provisions for rules pertaining to people you used to represent and no longer represent. So this could be a client whose matter you completed. It could be someone where you withdrew from the representation or the client fired you, or maybe you changed jobs and you're at a new firm now and the previous client was someone whose case was handled by your previous firm. Now, in this video, I'm going to deal with the provisions to Rule 1.9, sections A, B, and C, and comment 1, and I'm going to have subsequent videos that deal with the other comments so that this doesn't get too long. Okay, let's dive in. Rule 1.9a says, a lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client gives informed consent confirmed in writing. Now, that's kind of a mouthful, but look at what we're saying here. If you represented someone in the past, and that representation is over, they're no longer a client, you can't represent someone else who's bringing a claim against them or is the target of a claim by your former client if it's the same or substantially related matter, unless the former client gives informed consent confirmed in writing. Now, I do want to say, though, that if it's an unrelated matter, if you are bringing an action against a former client or representing someone who's on the other side of a transaction from a former client and it has nothing to do with the previous representation, note that you don't have to get consent. There is no conflict in that case. There would be a conflict if it was current clients under 1.7, but if it's a former client, you only have to get consent confirmed in writing if it's the same or substantially related matter. And then we get to B. A lawyer shall not knowingly represent a person in the same or substantially related matter in which a firm with which the lawyer formerly was associated had previously represented a client, 1, whose interests are materially adverse to that person, and 2, about whom the lawyer had acquired information protected by Rules 1.6 and 1.9c that is material to the matter, unless the former client gives informed consent confirmed in writing. So here we're talking about a scenario where either this is a past client of yours, or you've changed jobs and it's a client from your previous firm. It could be someone that other lawyers at that firm represented. You did no legal work on the case at all and didn't provide representation, but maybe you know some confidential information. Why would you know information about a case that you didn't work on? Well, lawyers in the same firm talk to each other about their cases. They discuss cases in staff meetings and things like that. And so if you have a new client, maybe because you've changed jobs, who wants to sue a client, even a client of your previous firm, and they're materially adverse interests, and you have confidential information that's relevant and material to this matter, that disqualifies you from providing representation to the new client unless the former client gives informed consent. So notice that it has to be someone whose interests are materially adverse to the previous client and that it has to be matter that's relevant. Again, if it's completely unrelated and so the information you know it has nothing to do with it, then this provision would not apply. 1.9c is just about using information. And so here we're kind of overlapping a little bit with the confidentiality rules, as you can see. A lawyer who has formerly represented a client in a matter or whose present or former firm has formerly represented a client in a matter shall not thereafter use information relating to the representation to the disadvantage of the former client, except as these rules would permit or require with respect to a client, or when the information has become generally known, or reveal information related to the representation except as these rules would permit or require with respect to a client. So here we're talking about using the information, not just about representation, right? And so we could be using the information to gain some sort of personal financial advantage with purchasing real estate or stocks or something like that, or revealing the information. Maybe you want to write a tell-all book about your career as a lawyer, or you have a blog where you want to talk about your former clients from the past. You can't do that without their consent if the information would be to their disadvantage, if the disclosure would be to their disadvantage. Now, in my course, we haven't covered confidentiality yet under Rule 1.6, but I do want to tell my students two quick things about it. So you have a duty of confidentiality to preserve or protect the confidentiality of your client's information, sensitive information. And that runs indefinitely. It doesn't end when the representation ends. So you have to keep that information from the representation confidential basically forever until the client authorizes you to disclose it. Now, 1.9c also has an exception, or says it doesn't apply if the information has become generally known in the meantime. So you represented someone a while ago. At the time, you were privy to some sensitive information, but in the meantime, maybe that a person has gotten a lot of media attention or published a book of their own, or for some reason it's become widely known, and a simple, even if everybody doesn't know it, a simple Google search would reveal the information. Well, then it's not really covered under this rule as confidential, and the prohibition on using the information. Now, I'm going to talk about comment 1 and a few of the provisions here. First, as I mentioned, a lawyer has certain continuing duties with respect to confidentiality and conflicts of interest, and thus may not represent another client except in conformity with this rule. So your duties to a client don't end when the representation ends. Even if the client fires you or you have to withdraw from the representation, you could still have some continuing duties, especially with regard to confidentiality and conflicts of interest. And then comment 1 gives some examples that I think you're likely to see as test questions. Under this rule, for example, a lawyer could not properly seek to rescind on behalf of a new client a contract drafted on behalf of a former client. So, for example, you either at the same firm you've always worked at, or you changed jobs, but you at one point represented a client, drafted a contract for them, and now, long after that representation ended, the other party to that contract wants you to represent them because they want to rescind that same contract. Well, I hope you can see that's the same or substantially related matter. You can't be the lawyer for that case unless the former client gives informed consent confirmed in writing. Let's talk about this in the context of criminal law. A lawyer who has prosecuted an accused person could not properly represent that same person, the accused person, in a subsequent civil action against the government concerning the same transaction. So it's pretty common for lawyers to maybe work as a district attorney for a while after law school and then eventually want to go into private practice. And so if that's you can't represent someone, let's say, well, you were a prosecutor, you prosecuted them and maybe they got acquitted, you didn't obtain a conviction, and so they now want to sue for wrongful arrest or defamation or something like that. Or you got a conviction and they eventually got their conviction overturned and now they want compensation. They're out of jail for their wrongful conviction. Or it could be something with asset forfeiture that occurred related to their arrest and so forth. In any case, if you were the prosecutor in the case, you can't then represent the defendant in a subsequent civil action related to the arrest and prosecution of that same case. Nor could a lawyer who has represented multiple clients in a matter represent one of the clients against the others in the same or a substantially related matter after a dispute arose among the clients in that matter, unless all affected clients give informed consent. So again, I've mentioned before these scenarios where a group of people come to you and they want you to help them form a business or an LLC together. It could be a group of musicians who want you to form a record label, and you did that for them. Maybe you had them give informed consent to the conflict of interest under 1.7 because that affected the original representation, advocating on behalf of each one's interests. But now, years later, one of them wants to sue one of the others or the whole group. You can't be the lawyer if it's the same over the same matter for the one who's turned on the others, unless all the others give informed consent confirmed in writing. The same would be true if you represent co-plaintiffs or co-defendants in litigation, and one of them turns on the other later on after the representation is over and sues in some way that's kind of substantially related to the matter that you handled. You would have to get consent from the other client to represent one against the other. Or you have a group that wants to go in together in a joint venture, let's say to buy a commercial enterprise or a commercial real estate, and then long after that representation is ended, a legal dispute arises between those former clients. If you're going to represent one against the others have to consent to you providing the representation. And that concludes my introductory video about Model Rule 1.9 covering the provisions. I'm going to make another subsequent videos covering the highlights from the comments that I think you're likely to see as test questions on the MPRE.